Oyez, oyez, the U.S. Supreme Court is now in session. All who have business before the court, please stand and be heard. All right, you all be seated. We are here today on one case that is docket number 2015-2016, Kadesh College and ARA petitioner versus United States respondent. I didn't mention this, but I will for the audience. Please be sure all cell phones are on silent and are off. Thank you. Are petitioners ready to proceed? Yes, sir. Respondents ready to proceed?
Yes, sir.
Be sure this will Oh, correct, the times. Have you already gone over the timekeeper your times?
Yes, Your Honor, we have.
All right. Mr. Webb, elected officials.
Before we begin, two preliminary issues. First, who is serving as our Chief Justice? And second of all, we request 3 minutes be reserved for rebuttal.
It is so easy.
I guess a third final preliminary issue. Would you prefer we use the microphone or just speak with our normal voices, Your Honors?
Why don't we use the microphone?
Thank you, Mr. Chief Justice. And is that volume okay?
Yes, Mr.
If the court's ready to proceed, then.
I'm sorry.
You need to ask the videographer if the volume's okay.
Is it good? Yes. Oh,
Thank you.
yes, Mr. Webb. Please go ahead.
Mr. Chief Justice, Your Honors, and may it please the Court, my name is Josh Webb, and I represent Kadesh College on the First Amendment. My co-counsel, Shane Roberts, represents Ms. A.R.H. on the Fifth Amendment. We'd ask this Court to hold the Fair Education Act unconstitutional under the First Amendment for two chief reasons. First, this Court should overturn its decision made in Employment Division v. Smith and revert back to applying strict scrutiny to any law that burdens religion, including the one before you now. Second, the Fair Education Act doesn't further or advance any compelling interests or even any rational interests, making it unconstitutional.
Before you begin, I have a few preliminary questions for you. What happened to A.R.H.'s father?
Your Honor, Miss A.R.H.'s father sadly died when she was just a baby, a few months after she was born.
What is Kadesh College's retention rate?
Your Honor, Kadesh College's retention rate is mentioned to be around 80%, which is around 20% higher than the national average.
What is Exodus Week?
Your Honor, Exodus Week is a term used to describe a period in Kadesh College's calendar year where prospective students come to the college and think about attend classes with their family, meet students and professors, etc., to sort of get a taste for whether or not they want to go to the school.
Can you briefly summarize Dr. Bronner's congressional testimony based on the record below?
Yes, Your Honor. Dr. Bronner testifies to the fact that for the past 50-plus years, Kadesh College has existed to help undocumented persons, and that the college's hands are being effectively bound from doing so through the legislation and the executive order you have before you now.
What happened in the district court?
Your Honor, the United States government prevailed at both the district and circuit levels according to our record.
Say that one more time, I apologize.
Your Honor, the district court and the circuit court found in favor of the respondent, in this case, the United States.
Why 512 students?
Your Honor, that number, admittedly, isn't, to my knowledge, significantly religiously important to Kadesh College. Kadesh College has simply decided that that number reflects its mission statement found in Psalms in the Bible, specifically chapter 5, and 11, and 12 verses in that chapter.
Can you briefly summarize the two previous federal laws we have on the record regarding education? And I'm talking about in-state tuition rates and federal student aid.
Yes, Your Honor. There are two federal laws in our record that regulate immigration and education. The first of those laws, I believe, regulates the tuition rates undocumented persons can receive, and the second affects the admissibility of undocumented persons in certain states and the federal government's relationships with states that choose to admit undocumented persons into their colleges.
You're referring to higher education and illegal immigration reform and immigrant responsibility?
Yes, Mr. Chief Justice, absolutely so. Now, with that said, in the words of this court in Ballard versus the United States, cited in the Smith decision, the founders of this country didn't view their dearly bought religious freedom to be a luxury. They viewed it to be an essential element of freedom, and it's because of that that the Free Exercise Clause fundamentally is written in to the First Amendment. Now, in the years leading up to this court's Smith decision, as pointed out by Justice O'Connor in that decision, strict scrutiny was applied to any law that burdens religion. But Smith arbitrarily and dangerously changed that. In Smith, 5 justices on this court's panel decided that religion should be condemned to second-class status. Smith made general laws that only incidentally burden religion almost immune from free exercise challenge.
If you state such a broad claim, how wouldn't all laws that incidentally burden religion would be subject to strict scrutiny?
Your Honor, that's how things operated prior to Smith, but unfortunately that's no longer the case. And that's particularly worrisome because, as Justice Blackmun noted in Smith, almost every law involved in this court's free exercise jurisprudence is general.
I understand you want us to overturn Smith, but can you talk to us briefly about hybrid rights?
Yes, Your Honor, I'd be glad to. And it's our contention that even though this court should overturn Smith, our client, Kadesh College, would still prevail even if the court decides not to, even if the court adopts hybrid rights doctrine. Now, that phrase, hybrid rights, refers to the idea that now, post-Smith, an appellant needs to bring up their religious claim and another non-religious claim to receive strict scrutiny protection. It's worth...
Give us some successful examples of that.
Your Honor, unfortunately, as the First Circuit points out in Parker v. Hurley, never before since Smith has an appellant prevailed under hybrid rights doctrine. And that points to the fact that Smith must be overturned. Because if you come forward with a religious claim, even using the crutch of having another right, a hybrid right, you will not win your case.
Let's talk about Thomas. What were the hybrid rights at issue in Thomas?
Your Honor, Thomas v. Anchorage Equal Rights Commission involved both religion and then the Takings Clause and free speech issues. And with that said, a substantial burden has clearly been placed upon my client's rights. According to pages 5, 6, and 9 of the record, for the past 50 years, Kadesh College has admitted undocumented persons into its institution. 3 separate cases, Brownfeld v. Brown, which is cited within Smith, Thomas v. Review Board, which is cited within Smith, and then Lying v. Indian Cemetery Association, which is cited within Grace United, say that when a government's law coerces you to not do something your religion would have had you do, that's the severest of burdens that the government can impose.
Is there anything in the Declaration of Faith, Psalm 511 and 512, or anything in the Kadesh College facts that indicate they must serve undocumented persons? It seems to me they must serve others, whoever they may be.
Your Honor, to be honest with you, there's sort of 2 answers to your question. On the one hand, yes, we have indications that Kadesh College specifically needs to help undocumented persons. Those indications come first from page 5 of the record, which mentions that Kadesh College exists to be a refuge. Now, it's hard to be a refuge when you explicitly exclude a certain portion of people.
But certainly a refuge could be to the mentally ill, to the poor, to those documented persons who can't get into other colleges.
That's very true, Mr. Chief Justice. But Kadesh College also specifically sets aside scholarships for undocumented persons.
With all due respect, a scholarship, correct?
Mr. Chief Justice, the actual wording of page 6 of our record is at least 1 scholarship. So we know that they reserve at least 1 and possibly more scholarships. But second, even if the government somehow tries to argue that helping undocumented persons isn't really what Kadesh College believes, a substantial burden still exists pursuant to those 3 cases that I just cited. Pursuant to Brown, pursuant to Lying, and pursuant to Thomas, if a law is coercing you to not do something that your religion would have had you do, a substantial burden exists.
I'd like to take you back to hybrid rights briefly. Can you just lay out an intimate association claim for under hybrid rights?
I'd be glad to, Mr. Chief Justice. The cardinal case there is Roberts versus Jaycees. They mention that a private or intimate association is an association that exists to further the sort of emotional well-being of the members within it. And they laid out a number of criteria that could qualify you or disqualify you from being an intimate association. Now,
What are those criteria?
Mr. Chief Justice, those criteria include size, selectivity, involvement with the outside world, a sort of admissions rate, if you will, into the association, etc.
What are some examples of relationships discussed in Roberts that were considered intimate?
Mr. Chief Justice, there's a couple mentioned. The first is the family relationship between parents and their children. A second is the spousal relationship between a person picking who they're going to marry. And a third would be parents deciding that they're going to adopt a child.
Can you talk to me briefly about expressive association?
Mr. Chief Justice, I see my time's about to expire. May I answer your question and briefly conclude?
Yes.
Thank you. Expressive association doctrine is also laid out in Roberts, and it's said to be when an assembly comes together and engages in something protected by the First Amendment. Kadesh College could be considered an expressive association because it's engaging in education, something that, according to Roberts and University of Michigan versus Ewing, is protected by the First Amendment.
Question, Mr. Webb. Why do we need expressive association? It's not in the First Amendment in the text at all, and people have the right to speak already.
Mr. Chief Justice, may I answer your question since my time's expired?
Yes.
Thank you, Mr. Chief Justice. The Roberts Court notes that expressive association is uniquely important because the ability to vie for a particular position, specifically an unpopular position, is inevitably strengthened through group association and through a lot of people speaking on behalf of that same issue. Mr. Chief Justice, may I briefly conclude as well? Thank you. Your Honors, Smith was dangerous. Smith condemned religion to being virtually non-existent. It's because of that we'd ask you to overturn Smith, apply strict scrutiny here, and strike this law down since the government hasn't met their burden of proof under strict scrutiny analysis. Thank you, Your Honors.
Thank you, Mr. Mr. Roberts.
Mr. Chief Justice, Your Honors, may it please the Court. My name is Shane Roberts, and I represent the interests of Ms. ARH, the petitioner, on her Fifth Amendment claim against the Fair Education Act. Your Honors, today we ask this Court to rule very simply that the Fair Education Act is a prime congressional example of the U.S. Congress trying to achieve an illegitimate goal through illegitimate means. We ask for that ruling for three elementary reasons, time permitting. First, irrespective of any standard of review, the federal government's Fair Education Act is a prime example of the federal government illegitimately usurping state police power over education. Secondly, because the Fair Education Act is punishing Miss ARH for the immigration sins of her parents, this law should be given an intermediate standard of review. And lastly, the Fair Education Act fails intermediate scrutiny because the government has not advanced a substantial interest in a way that's furthered by the law.
Again, I have to talk to you about your first point, and I don't want to misrepresent what you said. It's an illegitimate goal that the government is seeking to profit here?
Your Honors, the government is effectively punishing children for the immigration sins of their parents.
Well, again, I don't want to get into it. I want to make sure it's means versus ends here. The goal is, even the goal of fiscal conservation of funds is legitimate, correct?
According to Graham versus Richardson, it may be legitimate, but it's not rational, it's not substantial, and it's not even compelling. However, as this court previously noted in the...
Hang on, Councilman. I think the Chief Justice is trying to get at me. First of all, the federal government has plenty of power over immigration.
That's true, Your Honor.
And a large aspect of the Fair Education Act is the federal government's effort to regulate immigration. Is it not?
That's true, Your Honor.
And is it in fact not the case that the federal government is trying to disincentivize illegal immigrants from coming to this country?
Yes, Your Honor. And turning...
Well, doesn't the federal government have the right to do that?
No, Your Honor, not in this case. And turning back to your question, Mr. Chief Justice, it may very well be a legitimate and even compelling goal of the government to try and effect a change in stopping illegal immigration, but, however, the Fair Education Act affects no such change. Now, this court doesn't even have to use...
Why does it not affect any such change?
Simply because it does not further the interests of the Act as stated on page 2 of our record. Your Honors, the federal government gave...
I want to be clear on that. Does it actually, are you referring to that, or tell, if that sounded like a conclusion, tell me why it doesn't further.
Certainly, Mr. Chief Justice. Before doing that, it's imperative that this court note the interest that the federal government itself gave to this court. You can find those on page 2 of the record in the last paragraph. The two goals stated are, first, the preservation of scarce education resources, and second, giving education to those who contribute. Your Honors, there has been no question whether there are scarce resources in education. And even if scarce resources were the goal of the government, it is an illegitimate goal pursuant to this court's own precedent in Graham versus Richardson.
But again, let's say a couple things. If the federal government is interested in preserving scarce educational resources, doesn't the federal government have the right to pursue that as an objective?
No, Your Honor, it does not, because it treads on the state's police power over education.
Right, but I mean, the state's police power over education isn't to the exclusion of the federal government. I mean, the federal government, for example, has enacted the No Child Left Behind law. That clearly has some policy impact on education. And you're not arguing here today that the No Child Left Behind law is somehow an impermissible use of federal authority, right?
No, Your Honor, I'm certainly not.
Okay.
But
So we can establish at the outset the federal government has some ability to regulate educational policy.
that's correct, Your Honor.
Okay. And so if the federal government has some ability to regulate policy, right now, by the way, we're not talking about implementation. I realize you're going to argue that this is an inelegant implementation, but doesn't the federal government have some right to be concerned about the scarce educational resources?
Your Honor, they have a right to be concerned about it. They have the right to state those goals, but if they use an illegitimate mean to accomplish that goal, this law unconstitutionally violates the equal protection of Ms. ARH.
Okay, so why is this an illegitimate means?
For one reason and one reason only, Your Honor, and that is that the federal government did not preempt or take preemption over the state's police power over education.
What would you say to the argument that field preemption applies here, and that based on Arizona, Congress has dominated the field of immigration, and thus they need not explicitly state that they intend to preempt state law?
Because, Your Honor, it trepidates on the very police power that states have been granted in many cases on our record. In Brown v. Board of Education, as cited in Plyler v. Doe, in Plyler, in the University of California Board of Regents v. Bakke, as cited in the University of Michigan v. Ewing, and in Ewing, this court recognized that states have police power over education. And there's no denying here that this policy involves both immigration and education.
Counsel, correct me if I'm wrong. We try to read statutes to be constitutional where we reasonably can do that.
That's correct, Your Honor.
Let's start. I'm assuming you're talking about Section 6.
Yes, Your Honor.
Section about post-secondary schools violating any state, local, or federal law. Correct?
That's correct, Your Honor.
So why couldn't I interpret that to say, okay, you can't violate any of those three laws. Federal law is the widest, the strongest, so by process of elimination, it conflicts with state law, which allows more behavior. Because you have to meet all three, federal ends up trumping state.
Your Honor, that's not entirely true because federal law in this particular circumstance is not the strongest type of law. There's one...
Let me say it a different way. The federal law issued here, the Fair Education Act, prohibits conduct that the state law permits, correct?
No, Your Honor, it doesn't. Nowhere in the text of the Fair Education Act did the federal government try to take preemption over state police power. There's one central test that can clear this whole issue up, I believe, Your Honors. It was cited very clearly in this court's precedent in Rice versus Santa Fe Elevator Corporation, as cited in Arizona. Now, for preemption, I'd like to quote this test, where the court said, quote, "In preemption analysis, the courts must assume that the historical state police power is not superseded, unless that was the clear and manifest purpose of Congress."
Counsel, I feel like we may be going in a circle. Olympus education law appears to allow undocumented persons to attend college.
It most certainly does, Your Honor.
Absolutely. Okay. Well, the federal law does not, because the Fair Education Act does not allow this. Fair education in conjunction with college.
That's correct, Your Honor.
So Dr. Bronner, to admit ARH would violate federal law by doing so, and thus the Fair Education Act would ban that, effectively preempting Olympus state law.
No, Your Honor. The federal government waived its plenary authority in immigration in Section 6 of the statute, where it states, and I quote, "No part of this law, or nothing in this law, shall be construed to authorize a post-secondary school to violate any local, state, or federal law." Now, respondents may stand up here and try to argue that the government has a plenary power to regulate immigration pursuant to Matthews and Arizona. However, immigration power of Congress comes into direct contact and conflict with the state's police power over education.
Can you briefly distinguish Graham from Matthews?
Yes, Your Honor, Graham was concerning the preservation of scarce resources, and the government struck down that policy.
Now, to be clear, you talked about earlier how Graham involved an illegitimate interest. Wasn't there a fundamental right to travel at issue in Graham?
Yes, Your Honor, that's correct. However, it has no bearing on this case today. Even if Your Honors did apply a standard of review, the correct standard is intermediate scrutiny pursuant to this court's precedent in Plyler v. Doe.
One last question. Can you walk me through Henry Griffiths, more specifically the government's interest in Henry Griffiths?
Your Honor, I believe the interest in Henry Griffiths was to bar undocumented persons or illegal aliens from taking the bar exam and practicing in the United States of America.
Legal aliens.
Yes, Your Honor, I believe. No, Your Honor. No, Your Honor, it was legal aliens in Henry Griffiths. And that's the central bearing that it has on this case here today.
What was the state's interest in that?
Well, the state's interest in that case was to preserve those resources for individuals who are actual citizens and not legal residents.
Can I take you back to something? I know you're arguing conflict of laws with respect to the federal and state statute. So the state statute, so tell me exactly what part of the state statute is being violated by the federal statute saying what it says?
Mr. Chief Justice, I see my time has expired. May I respond to the Justice's question?
Absolutely.
Specifically, Your Honor, on page 25 of our record, the Fair Education Act is directly contradicting the state's police power over education in the excerpted portions of the law that we have, specifically sections 3 and 4. Mr. Chief Justice, with that, may I briefly conclude? Your Honors, it's clear looking at the precedent here today that this court doesn't even have to apply any standard of review to the Fair Education Act to see that it is illegitimately trepidating on the state's police power over education, which violates my client's equal protection rights under a double standard. And even if this court did apply a standard of review, it should be intermediate scrutiny, and the government just can't pass that level of review. For those reasons, we ask this court to find the Fair Education Act unconstitutional pursuant to the Fifth Amendment.
Thank you, Mr. Roberts.
Mr. Chief Justice, and may it please the Court. My name is Caleb Ingle, and I, together with my co-counsel, Christopher Baldacci, represent the United States government as the respondents in this case. I will address Kadesh College's First Amendment claims, and my co-counsel will address Ms. ARH's Fifth Amendment claims. The Fair Education Act is a reasonable attempt on the part of Congress to exert its broad and plenary power over the area of immigration. And to this end, we offer 2 points of argumentation. First, we contend that Kadesh College has not demonstrated a substantial burden on its freedom to exercise its religion. Additionally, we contend that the government has multiple rational and even compelling interests served by the Fair Education Act.
Before you get to that, Mr. Ingle, I asked Mr. Webb a series of fact questions based on this record. Do you have any dispute as to any of Mr. Webb's answers?
No, Your Honor. Addressing the first issue, Kadesh College claims that there is a burden placed on its free exercise rights. However, as this court ruled in Reynolds v. United States, as cited in Employment Division v. Smith, only the right to believe is absolute. The right to act on those beliefs is necessarily limited. So in examining Kadesh College's free exercise claims, it is to this court to determine whether or not Kadesh College is applying this doctrine to claim an absolute right or the proper limited right, which free exercise is. And Kadesh College in this instance is claiming an absolute right to the free exercise of their religion.
Examples of laws based on Smith or any other cases of laws that concern conduct, and we distinguish conduct from belief.
Laws which distinguish conduct from belief specifically.
Under free exercise, the difference between a belief in something and conduct. Religion doesn't get you out of committing certain conduct.
Your Honor, are you asking for statutes or court precedent?
Court precedent.
Your Honor, in Minersville v. Gobitis, as cited in Smith, this court explicitly stated that religious beliefs do not relieve an individual of one's political obligations. And that's exactly the case in Kadesh College.
Where was that case under?
Employment Division v. Smith, Your Honor.
Do we know what the political obligations were in that case?
Your Honor, I believe the political obligations in Gobitis were obliging the children of Jehovah's Witnesses to salute the flag, which they believe violated their free exercise rights. Now, Kadesh College claims the absolute right to admit absolutely anyone into their college in spite of any reasonable interests which the government may have in limiting that free exercise through reasonable laws.
You're using some pretty dramatic words there, absolute right and so on. I mean, first of all, in the Smith case, wasn't and I can't remember if Smith had a file, I may have decided the wrong case now. But, I mean, the statute issue in the case that involved the Coyote, which case is that? Is that Smith?
Your Honor, that's Employment Division v. Smith.
Okay, that is, right. So, I mean, first of all, that was a criminal law case, was it not?
Yes, Your Honor.
And isn't that pretty distinguishable from, so the government has a pretty powerful interest in wanting to keep people from just skirting the criminal law because of their religious belief, correct?
Yes, Your Honor.
Okay, so here we have a situation that doesn't involve criminal law. It simply involves basically a college wanting to admit a particular category of people, and that category of people is in keeping with the college's religious mission. That seems to me like it's a pretty dramatically different scenario from what was at issue in the Smith case, is it not?
Your Honor, this is a fairly different scenario. However, the Court in Employment Division versus Smith made no distinction between civil laws and criminal laws.
I thought Smith was an unemployment benefits case. How is a criminal law issue in Smith?
Your Honor, Smith specifically addressed the denial of unemployment benefits to the appellants in that case because they desired to take peyote as part of their free exercise. Now, this was based exclusively on the fact that Oregon outlawed the use of peyote as part of its criminal statutes. So the fundamental issue at question in Smith was the criminalization of peyote.
What would you say to an argument that this law targets Kadesh College because its entire mission is to dedicate to undocumented persons? So this law is unlike Smith in that it is not neutrally generally applicable.
Your Honor, we contend that this law is not targeted specifically to the college in question. As this court has held, as cited in Grace United Methodist in Lukumi Babayu I versus City of Hyala, a law is only targeted towards religion if the intent of that law is to restrict a practice because it's based on a religious belief.
Based on Lukumi cited in Grace United, why was that law targeting religious practice? The law regarding animal slaughter targeting religious practices?
Because, Your Honor, in that instance, the court found that the City of Hyala had passed that regulation exclusively because the Church of Lukumi Babayu I was sacrificing animals, and there had been no other reasoning given in the passage of the law for having that regulation other than that specific religious practice.
Can you talk about the under-inclusiveness of that law?
Yes, Your Honor. The law in that specific instance only targeted animal sacrifice and not generally animal abuse, indicating to the court that this was specifically targeted to the practice of Lukumi Babayu I Church Incorporated.
I
And thus,
asked Mr. Webb about hybrid rights, and I know that you're spending time on substantial burden understanding this. So can you walk me through intimate and expressive association?
yes, Your Honor. Intimate and expressive associations were best articulated by this court in the case of Roberts versus Jaycees, where it addressed both in relation to the rights of the Jaycees Club to associate with persons and specifically to discriminate against women in their association. The first issue this court addressed was intimate association, where it used three prongs to determine whether or not the Jaycees Club was actually an intimate.
Let me try. I mean, I think we can agree that the college is an intimate association in the way but why is it not an expressive association?
Your Honor, there are two particular reasons why Kadesh College does not fall under the category of expressive association. The first reason is that any claim to expressive association on the college's part would be exactly the same as their claim to free exercise. And as the 10th Circuit ruled,
Hang on there. I mean, so the college, I mean, I think the college's message is not uniform. So the message is that they basically, part of the expressive message is that they want to offer a haven, a safe haven basically, to undocumented aliens who are in need of, who are already present in the country, but are in need of education. So that is not a religious message. It ties into the religious message in the sense that they believe that part of the motivation for doing that is basically because it's essentially being advocated for in certain passages of the Bible. But it seems to me that at least a large part of that, it goes beyond the strictly religious part of the message and is an independent expressive message in and of itself.
no, Your Honor. As petitioners claim, and as the facts of the record substantiate, Kadesh College's desire to minister to undocumented persons flows directly from their religious beliefs, and thus the expressive association claim is tied directly to the free exercise claim.
Okay, something can flow from it. Let's take for example, the case of abortion, which is obviously a politically charged issue. Now, people can be opposed to abortion, and the source of their opposition may be religious belief, but then abortion becomes an independent political objective, and you can be pro-life and have that as an independent expressive political objective, which isn't just confined to the religious motivation.
Yes, Your Honor. However, that analogy is not applicable to Kadesh College. As the Third Circuit Court ruled in Salvation Army, expressive association is part and parcel with free exercise claims. And in that case, the court ruled, and we asked the court to rule in this case, that expressive association claims combined with free exercise claims do not compose a hybrid right, but rather a duplicative claim.
Let's talk
Yeah,
about
with all due respect, but I actually thought the analogy was pretty good. I mean, I'm not sure where the analogy breaks down, because, I mean, both of them have political components and religious components. So there's a political message which may have an underlying religious motivation, but the political message still survives independently. I'm not sure I see where the difference is.
Yes, Your Honor. The differentiation draws between the fact that the abortion analogy would be political advocacy, which flows from someone who has certain religious obligations. However,
About education.
Yes, Your Honor.
Talks about academic freedom, the right to express ideas together, unimpeded by the government. What would you say to an argument that this is part of Kadesh College's educational mission, and as such, it is a right divorced from religion, but rather educational speech?
because, Your Honor, in this instance, the government is not forcing Kadesh College to not associate or exert its discretion in making academic decisions. The fair edu-
They can't take certain students that they want to take. Dr. Bronner wanted to take ARH, but then I had to tell her, sorry, the federal government told me I can't.
Yes, Your Honor. But Regents of Michigan University versus Ewing dealt exclusively with academic decisions, particularly in the area of what the judicial kin was. As regards Kadesh College, this is
It's not an academic decision. She's in, and now she's out.
because, Your Honor, the Fair Education Act, I'm running out of time. Is it all right if I have time to answer your question and briefly conclude? The Fair Education Act, as applied through DACA, does not exclude Kadesh College from accepting undocumented persons or making these decisions. Rather, it makes reasonable exclusions based on duration of residency requirements, which this court laid out in Matthews, and criminal prohibitions, both of which we argue are reasonable. And for that reason, we ask this court to uphold the Fair Education Act as constitutional. Thank you.
Mr. Malvachi.
Mr. Chief Justice, Your Honors, and may it please the Court. My name is Christopher Baldacci, and I rise to continue argumentation for the respondent, the United States government, in response to Ms. ARH's Fifth Amendment claim. The Fair Education Act, as implemented by DACA, represents a legitimate exercise of the federal government's authority to take into account the character and duration of an alien's residence within the United States. And for this reason, we would ask that you hold the legislation constitutional. We offer two arguments. First, the correct standard of review is indeed rational basis because of the federal government's plenary authority over immigration and naturalization. And second, the government meets this standard because they have a legitimate interest in promoting the advancement of long-standing and law-abiding residents of the United States.
Why doesn't Graham stand in your way?
Your Honor, Graham v. Richardson was a state law which dealt with whether or not people could take advantage of welfare benefits in the state of Arizona. This is dealing with a federal law, and so we believe the controlling case should be...
So hang on for a moment. I thought, you correct me, I may be wrong on this, but I thought that part of the Smith decision was essentially, if you look at it's kind of in a historical context, that historically what was required was strict scrutiny analysis when the First Amendment was written on. Then Smith comes and does kind of a detour out of that historical line of cases. And that part of the Smith logic was that it involved the 14th Amendment as opposed to the Fifth Amendment, state action as opposed to federal action, and that part of what's left after Smith is that strict scrutiny can still apply to Fifth Amendment cases. Is that not true?
Your Honor, the Smith decision really gives very little by way of what would happen if a hybrid rights claim fails. Some of the district courts have interpreted the fact that if a hybrid right claim fails, that rational basis review should be applied. However, some district courts believe that if a hybrid right claims failed, no standard of review is met, and the challenge simply fails on face. However, what we're dealing with here...
Undocumented persons protected under the 14th Amendment, and by extension the Fifth Amendment.
Yes, Your Honor. In Yickwo v. Hopkins, which was cited in Graham v. Richardson, Plyler v. Doe, and even in Matthews v. Diaz, recognize that undocumented persons are persons protected by the 14th Amendment, and therefore by extension the Fifth Amendment. However, Matthews v. Diaz critically holds that just because undocumented persons have equal protection rights, this does not preclude Congress's authority to make distinctions within the class of undocumented persons. And that's the key distinction here. What the DACA Amendment does is make this not a black and white issue anymore, or a distinction between documented and undocumented persons, but rather what class of undocumented persons is allowed to attain higher education. And in
Can't we make the argument that DACA essentially is kind of a feeble effort to rectify the constitutional reforms, at least in the Fair Education Act?
Your Honor, the DACA amendments do change the implementation of the Fair Education Act, and we would argue that they do make it more constitutionally palatable. But that's the part of the case that we make before you.
Would you argue, would the Fair Education Act on its own stand up to equal protection clause scrutiny?
Your Honor, the government does have an interest in protecting higher education for long-standing and law-abiding citizens of the United States. But we would argue that it's especially pertinent to view the Fair Education Act.
But counsel, I mean, answer the Chief Justice's question. Let's assume for a moment that DACA is never implemented. The Obama administration never goes in that direction. So now we're here with the same set of facts and the question about the constitutional infirmity of the Fair Education Act. So where would you stand on that?
Your Honor, specifically, we would stand by this court's decision in Arizona versus United States that even such blanket discriminations could fall underneath the federal government's plenary authority over immigration.
Can you walk me through Arizona? There were 3 sections of the Arizona law that were preempted. Can you walk me through those?
Your Honor, the 3 sections in Arizona that were preempted, these were state regulations that were preempted by the federal government. There were more than 3 issues in question in Arizona. However, they held that 2 of them where there was no sufficient regulation by the federal government to preempt them, and so they stood, and then 3 of them were preempted by the federal government.
Let me ask the question differently. I believe at least 2 of them stated new state laws. What behavior was Arizona trying to stop in enacting the state laws?
Your Honor, Arizona's intentions in enacting the state laws was to discourage immigration. They allowed police officers to characterize as well as stop and frisk people simply based off of their ethnicity. These were measures that Arizona took in the realm of immigration because they believed federal immigration statutes to be insufficient.
Well, counsel, and maybe I'm blurring the lines here, didn't Section 2B say they could only do so in accordance with the Arizona and U.S. constitutions?
Yes, Your Honor, they did.
So how can you distinguish the preempted law from the remanded law that was allowed?
Your Honor, the key finding in the Arizona law was that when the federal laws and state laws on immigration conflict, the federal law takes supremacy always. And when there wasn't enough evidence to either A, judge the congressional intent of their regulatory scheme, or B, a regulation in the first place, the state law could stand as long as it did not violate the Constitution.
Can you give me the other 2 laws?
Your Honor, I don't remember the specific details of the other 2 laws. However, I would point you to a critical finding in the Arizona case.
Just in the interest of time, can we take a detour into another direction? Because I'm a little concerned when it comes to preemption that you've got the Fair Education Act, which is a federal act, and it's trying to regulate certain aspects of education. Now you have the act of the state of Olympus. Now the Fair Education Act says, and I forget what section, basically, that this act isn't intended to abrogate or require any violation of state law. And yet, my reading, particularly as it's applied to ARH here, is that it does in fact violate state law.
Yes, Your Honor. I believe it's a misinterpretation by the petitioners to suggest that Section 6 doesn't allow this law to infringe on any state laws at all. On page 2, paragraph 3 of the record, it's clear that the intent of Congress was that there should be no undocumented person enrolled in any college across the United States by the year 2015.
But counsel, isn't it also equally clear that the state of Olympus has made a policy judgment, an educational policy judgment, that they want to afford to all of the residents of the state of Olympus basically in-state tuition? Is that not the policy judgment of the state?
Yes, Your Honor, that is the policy.
Doesn't the federal law violate that policy judgment or contradict that policy judgment directly?
Yes, Your Honor, and petitioners seem to suggest that this pushes them into an illegitimate overruling of state education power. However, we would hold that this is a legitimate exercise of federal immigration power. In Matthews...
Let me stop you there. Federal immigration power, okay, maybe, but is it a legitimate exercise of federal education policy?
Your Honor, we would argue that it isn't an education policy at all. Rather, that it uses education as a means to implement its immigration
But it's not completely divorced from education.
No, it's not. However, this court in both Matthews and Arizona upheld laws which use other methods, such as education, to uphold federal immigration statutes. The biggest...
The thing that troubles me is that the state education law here it's pretty specific. It's not vague, it's not general. It makes a very specific policy finding, and that policy finding is in fact grounded in facts that are on the record. And those facts are that when undocumented aliens are educated and receive post-secondary education, they become a net economic benefit to the state. So the state has a powerful reason for wanting to enact this policy. Here you've got a federal law that says we don't want to contradict state policy, and now we're going to contradict state policy. I mean, it just seems to me that it's a problem, and in fact that if you don't want to contradict state policy as a federal matter, then you're going to have to provide the exemption that's in the state law.
Your Honor, three things in response to that question. First of all, Matthews v. Diaz argues that the plenary power of Congress extends to regulating what they call the status of an alien within this country, which is what the law certainly does. Second of all, a more reasonable reading of Section 6 of Appendix 1, outlining in the Fair Education Act, is that once the federal government has preempted state laws, since that was clearly the intention to disallow undocumented persons from going to college, the state cannot construe that to apply to any of their other educational policies. And then third and finally, this court has upheld the federal government's plenary authority to override state policies in regards to status. Most specifically in Arizona versus the United States, they upheld the Immigration Control and Reform Act as cited in Hoffman Plastic Products versus the National Labor Relations Board, which criminalized employers who hired undocumented persons. This was using employment in order to effect an immigration scheme of the government, and this is underneath their plenary power.
I have one other question for you, Counsel. Can you walk me through Bernal and more specifically the government interests at issue with Bernal?
Your Honor, Bernal versus Fainter dealt with a case of whether or not a documented alien could become a notary public, and the court simply found that there was no reason to suggest a documented immigrant would be less able to do the job of a notary public.
Specifically, what were the government's asserted interests in Bernal?
Government's asserted interest in Bernal was that a citizen would be a better notary public and would have more affinity with the United States than a documented immigrant, which the court found no rationale. My time's concluded. Could I briefly wrap up?
Yes.
Your Honors, because of the nature of this law, because it is underneath the plenary power of the federal government, we would ask that you hold consistent with Matthews v. Diaz and grant Congress the wide deference that it deserves in implementing an overall regulatory scheme. And for this reason, we ask that you hold the law constitutional. Thank you.
Thank you, Mr. Bernal. Mr. Webb, floor one.
May it please the Court, through the Fair Education Act, the federal government is forcing a private, religious, nonprofit college to exclude and discriminate against an entire class of persons. Your Honors, 2 points of rebuttal. On the First Amendment, my client is simply looking for recognition that the Fair Education Act places a substantial burden on its religion. Opposing counsel tried to cite Reynolds versus the United States and stipulate that beliefs are different than actions.
Just to be clear, with your opening, your intro there, what is the class of persons that is at issue here? Is it undocumented persons or undocumented persons who are not not 8-year residents and have committed crimes?
Mr. Chief Justice, it's undocumented persons on the whole, but there are specializations at play as well within DACA. Now, with that said, the Fair Education Act coerces Kadesh College to not do something that it's done for the past 50 years, to admit undocumented persons that it feels God has asked them to admit. And through 3 separate cases, Brownfeld versus Brown, cited in Smith, Lang versus Indian Cemetery Association, cited in Grace United, and Thomas versus Review Board, cited in Smith, that's the severest of burdens that can be opposed by the government. That means that strict scrutiny should be applied here.
Counsel, did you have a Fifth Amendment issue on the vote?
Absolutely so, Your Honor. On the Fifth Amendment, this law is just de facto unconstitutional. And that's because, according to Arizona versus the United States, when federal plenary immigration power collides with state police power in areas like education, the federal law is only constitutional if the federal government expressly says that it wants to use its plenary power to make its law superior to the state law.
Well, Counsel, let's say we disagree with you and that we go to traditional equal protection clause analysis. Is education a fundamental right?
No, it's not, Mr. Chief Justice.
Are undocumented persons a suspect class?
No, they're not, Mr. Chief
Why
Justice.
are they not a suspect class?
Your Honor, they are not a suspect class according to Plyler v. Doe directly because documented status isn't an immutable characteristic. However, what is immutable is that undocumented persons like ARH are brought to this country by their parents. And Plyler v. Doe decided to protect these persons with intermediate scrutiny because people brought here by their parents shouldn't be disadvantaged since they didn't bring themselves here illegally.
Sure, but we're not dealing with ARH at age 6. And isn't there an immigration law cited in Arizona which requires her at the age 14 to sign up as a documented person? So at age 6, sure, but now she's 18, she's out of the class.
Mr. Chief Justice, my time's about to expire. May I answer your question and conclude?
Yes.
Thank you. Now, the law in Arizona notes that undocumented persons become legally culpable for their legal status when they become 14. That doesn't mean that it's just, pursuant to Plyler v. Doe, to punish undocumented children whose parents brought them into this country. Your Honors, in the First and Fifth Amendments, the government hasn't even tried to defend this law on intermediate or strict scrutiny. Those are the proper tests, and it's because of that that we'd ask you to strike this law down under those sections of our Constitution. Thank you, Your Honors.
Thank you. Welcome back. I just want to say one thing in closing. We talk a lot about it these rounds about pride. You made your school proud. You made yourselves proud. Your parents, everybody involved in this process, it's not just you. You know there's a lot of people around you. You made them all proud today. You made this panel proud. You stood for the highest standards of undergraduate education, and I salute you. It was an honor to sit before you. We had to make a call. It was a 3-2 decision. This year's winner is the petitioners.